Hey, I'm sorry, I did it by mistake. What happens if someone says like that? Yes, we have already seen mistake under IPC, that is mistake of fact and mistake of law. But under law of torts, what happens? Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in the series of law of torts, we are focusing on general defenses against tortious liability, and in that series, this is my 7th video. In the first video, we have discussed all the general defenses available in a single presentation, and then we started discussing one by one in detail, and this is the 6th defense that we are discussing, that is mistake. How are we approaching this video? We are first understanding what is mistake and then discussing very important case laws related to mistake. But before we start anything, let's quickly see the first two slides, which is repetitive. The first slide, which we are seeing the list of general defenses, and then one quick slide on mistake, which we have seen in the video number 1. After that, everything is new. Not taking much of your time, let's get into the first slide. This slide we have already seen when we done the introduction session, where we have understood the general defenses against tortious liability, and the list contains 11 defenses starting from voluntary non-fit injuria, plaintiff the wrongdoer, inevitable accident, act of God, private defense, mistake, necessity, statutory authority, act of the state, parents having parental or quasi-parental authority, and acts causing slight harm. We have seen this slide also, but it is very important to understand this slide, so I will repeat the contents here. Now remember, when we studied Indian Penal Code, their general exceptions, we have discussed mistake of fact and mistake of law, and we understood mistake of fact is a general exception, but mistake of law is not an exception. But under law of torts, even mistake of fact is not a usual defense available with the defendant. Remember, only on case-to-case basis, court might consider sometime mistake as a defense. Most of the time, mistake is not considered as a defense under law of tort. Like if you have wrongly published something, wrongly did auctioning of something, all of these will not be considered as a defense. Though you have done it by mistake, there will be some liability coming on you, or you have to pay compensation to the plaintiff or damages to the plaintiff. That way, mistake is not a very easy defense available, but on case-to-case basis, under law of torts, sometimes it is used as a defense. Now, let us try understand this in more detail. Now, this is the heart of our presentation. Here, we are approaching 4 important aspects. First, we are understanding the meaning of mistake, and then we are understanding the difference between mistake and accident quickly. I am elaborating the difference of mistake and accident in my next slide, but most of the time people think that mistake and accident are one and the same, but basically they are not the same. So we need to distinguish them. That also we are doing here. And then we are understanding 2 types of mistakes, that is ignorantia juris and ignorantia factum, or mistake of law and mistake of fact. And lastly, we are trying to understand what are the different types of mistakes and how they are not excluded as a defense under law of tort. So that way this slide becomes one of the most important slide in this presentation. First thing first, what is a mistake? Mistake is an act or judgment that is misguided or wrong. It is done by some misjudgment or done by some wrong interpretation or understanding. So that is the meaning of mistake. Now, what is the difference between mistake and accident? Now, if I have to read out quickly, a mistake is something that happens due to your action, thought process, or perception. You are thinking something, your thought process is making you to judge something in a particular way. All of that is mistake. But what is an accident? An accident happens when something goes wrong and you had no control over it or were careless. In mistake, your thinking process makes you to think something as in some way. Whereas in accident, something goes wrong. You want to do something, but something goes wrong and something happens on which you don't have any control. That is accident. Now, it might confuse you further, but in my next slide, when we discuss the case law, you will clearly understand what is a mistake and what is an accident. If I have to give quick example for mistake and accident, imagine you are going to a marriage and there is no one in the hall. And then when you call the bride or groom's home, They say the marriage is over. It was yesterday. Now what happened? It is a mistake. You thought the marriage is today, but it was already happened yesterday itself. So that is a mistake you have done. You have thought that the marriage is today. That is mistake. What is an accident? You are going on the road and you are driving in a particular speed. There is nothing in front of you and suddenly a cow jumps into your car. Now you hit the cow or dog or pig or something. Okay. Now if you hit it, it is an accident because you have no control over the thinking process of the dog or sometimes human also. They suddenly come and stand in front of your vehicle and you hit them. Now that is an accident because you never thought something like that can happen, but it happened and you have no control over it and you hit it. So that is an accident. Mistake is your thought process, whereas accident is mostly of action which you don't have any control over. So that is accident. I hope that gives a little bit of clarity, but we'll have clear clarity in my next slide where we are discussing a very important case law. Moving on to the next part, that is the different types of mistakes. There are two types of mistakes under law. One is ignorantia juris or mistake of law. The second one is ignorantia factum, which means mistake of fact. There is no exclusion under any law on mistake of law. That means I don't know this law is available, that's why I did this, and hence there is no punishment for me. If someone is arguing like that, that is not an exception under IPC or is a defense under tort, because you not knowing law will not help you. Okay, law is there and it is your responsibility or liability to know the law. That's how law treats you. Like for example, in India, smoking is not allowed in public places. If someone smokes in public place and later says I was not aware, it may be an Indian person or an abroad person. Okay, if they say I was not aware of this law, the law will not exclude you. You have to pay fine and law will not think that you are not educated on law, all of that. It is your liability, responsibility to know the law of the land, and if you don't know, that will not help you as general exception under IPC or under law of tort. That is what mistake of law. What happens in mistake of fact? Under mistake of fact or ignorantia factum, when we are discussing IPC, I have very clearly given an illustration where I said under IPC, mistake of fact is an exception. The general exception allows the person to get exception under mistake of fact. Like for example, a person has gone to hunt a tiger which was bothering the entire village, and he sees a bush where there is some movement and he thinks there is a tiger and shots, and then he realizes it is not a tiger but a person. Now he can take the exception under mistake of fact in the court, saying that I thought it is a tiger, we all went there to hunt the tiger and we were not aware that there is a person behind the bush, and then I thought that way and shot, so it is a mistake of fact. The court will give exception. Okay, that is what we discussed under IPC. But under law of tort, even mistake of fact is not an easy exception. Remember, mistake of law is never an exception under IPC or in tort, but mistake of fact in IPC is an exception, but under law of tort, it is not an easy defense. I hope that is very clear. For example, under IPC, if a police officer arrests Mr. A thinking that he is Mr. B, that is excused, or general exception is given to the police officer under mistake of fact because he genuinely thought that Mr. A is Mr. B. But under law of tort, it is not that easy. The police officer can be sued for false imprisonment and damages can be claimed. Because under law of tort, mistake of fact is not a very easy defense available. Saying so, it is seen case to case basis and then the court will decide. The different other examples for mistake of fact can be a person entering others' property by mistake, that will be sued for trespass and the person will be held liable, so it cannot be used as a mistake. Or wrong publish of something, the person may at later stage say that I did this publishing thinking that it is a genuine news, but then he can be sued for defamation and the publisher will have to pay compensation for such wrong publishing. On that we are discussing a very interesting case laws, or taking away someone else's property by mistake, that can be considered as theft and will attract compensation. All of that is the status of defense, mistake as a defense under law of tort. It is not usually given as a defense. Most of the time I think that why are they even adding this as a defense, because it is not an easy defense. It is a very difficult defense and mostly taken by the court on case to case basis. Now here the question of good faith or intent never matters. It is only the act of the person, because under law of tort the intent or good faith, all of that doesn't play very important role. That we have discussed in our early videos itself. So all of this will be considered as tort and the person is liable. But then sometimes it is considered as a defense, and to start with I will show one case law on such situation where mistake is given as a defense, and then two other case laws where mistake is not considered as a defense. Let's get into the first case law, because that aligns to the topic, because we are discussing mistake as a defense. So it becomes very important for us to understand a case law which is aligned to the topic, and then we'll go to the other case laws where the court has not considered this as a defense. The classic case to understand mistake as a defense under law of tort is Parrott versus Wells Fargo and Company. Now what happened in this case? This case law is famously known as the Nitroglycerin case. Okay, here what happened? Wells Fargo and Company is a courier company. Okay, they were shipping something from New York to San Francisco. The carrier came to their office, the courier came to their office, and there was some leakage in that courier. Okay, the carrier box or the courier, there was some leakage. So they thought, looking at that leakage, that it is sweet oil. Okay, thinking that, they tried to open it because it was leaking. They have to do some alternative. So in that thinking way, they opened it. But actually it was not a sweet oil. It was nitroglycerin. The moment they opened it, the box exploded. The result of the box exploding, the plaintiff got injured. Plaintiff was sitting there, so he got injured. Now he puts a case against the Wells Fargo and Company. Who is the plaintiff? Parrott. Parrott is the person who got injured. Now he asked the courier company to give compensation. Now here, first understand the difference between mistake and accident. Now the courier people, that is Wells Fargo and Company, the employees thought that it is a sweet oil. Okay, that is their thinking. They thought it is a sweet oil. That is mistake, because it is actually not sweet oil, but it is nitroglycerin in fact. Okay, what is an accident? When they opened, okay, the box got exploded. It is accident. They never thought that it will explode. Okay, so that is how you have to understand mistake and accident. Now the case goes to court. In the court said, as a courier company, they have taken sufficient care of the product that came to their unit, and in a regular day of business, whatever they could have done with any package which is leaking, they have done it that way. So it is in the course of their business, whatever could have been done in a particular way, they have done such action carefully, and hence there is no question arises to pay any compensation to the plaintiff or Parrott because he got injured. It is happened because their mistake. Okay, and it is an exception under accident also. So you can discuss this case law for mistake as a defense or accident as a defense. Okay, so this is the beautiful case law where we understand how mistake as a general defense is utilized, because here the defendant won the case, and you can also understand the difference between mistake and accident very clearly. I have given detailed notes for this particular case law. Pause the video, read the content, and go to the next slide. As I said in the beginning, under law of tort, mistake is not an easy defense available with the defendant. For that, we have two very important case laws. The first one is Morrison versus Ritchie and Company. What happened here? Ritchie and Company is a publisher, and they published a news saying that a particular lady got twins. Okay, she gave birth to twins. But in actual situation, the lady had got married just 2 months before. Okay. The publisher got confused and published this news. Now the pair, the husband and wife, put a case against Ritchie and Company or the publisher, and the publisher tried to say that I was mistaken. I thought they gave birth to twins, and in good faith I have published this news. My intention was not bad. Please give excuse. Or the publisher tried to use mistake as a defense, but the court said your news, okay, your mistake has caused defamation to the pair, and hence you have to pay the compensation. I hope this is very clear. The court has not given an opportunity to the defendant to use mistake as a defense, and the defendant had to pay compensation for the mistake that they have done. Okay, that way Ritchie and Company, the publisher, paid the compensation to Morrison. That is the first case law. The next case law is Consolidated Company versus Curtis. Here is the scenario. There is a company which does auctions of different things of different people. One fine day, a person comes to their office. We'll call that person as ABC, okay? This ABC person comes into the office and says, I have some materials by name X, Y, Z, etc. And you guys have to auction these things on behalf of me. Now the company thought, okay, ABC is the owner of these materials, that is XYZ, and we have to do auction. One fine day, they started the auction. Different people came, and in auction they have taken the materials, that is XYZ, etc. But later it was realized that ABC is not the real owner of these materials, that is XYZ, but someone else is the owner of those materials. The real owner put a case against the auctioning company. Now in the court, the auctioning company tried to say that we thought ABC is the real owner and in good faith we have conducted this auction. But the court said nothing doing, you have to pay the compensation to the real owner. Now you might be thinking that the auction company must have lost many money, etc. But I think maybe they have later sued the guy who came and told that these are his things. Okay, they might have sued ABC also. I don't know the further of this case, but that might have happened. But here what we need to understand that yes, they by mistake understood that ABC is the real owner of XYZ, but later they understood that it is not the case. He was not the real owner and someone else was the real owner, and whatever they have done in a good faith. But even then, though it was a mistake, they had to pay compensation to the real owner. That's how you need to understand, and that is where you need to understand that mistake is not an easy defense. I hope that is very clear. With that, I am handing over this presentation to Nishan.
Life is like a mirror. Mirror reflects everything in front of it. Likewise, if we are good to people, people will be good to us. As easy as that. With that, I am concluding this session. Please subscribe our channel. Please like, share and comment our videos. Thank you. Bye-bye.